Human Rights Council in order to extend the mandate of the working group of the 5 experts on the guiding principles. However, Ecuador, consistent with its position already outlined in 2011, presented in the same session an alternative resolution as a negotiation strategy that would make the group of 5 experts to work on a legally binding instrument. Due to the difficulties of the negotiation with the proponents of the resolution of the group of experts, which would later become Resolution 2622 of the Human Rights Council, Ecuador decided to articulate a powerful alliance with several countries and with approximately 500 NGOs, which would later become more than 1,300. This important alliance, with a varied set of international and organizations of civil society, allowed Ecuador, South Africa, and other allies to approve the famous Resolution 269 of June 26, 2014, by which an open-ended intergovernmental working group was established to elaborate an internationally legally binding instrument, which has been chaired ever since by the permanent representatives of Ecuador to the United Nations in Geneva. Therefore, the process of the elaboration of an international treaty on business and human rights constitutes, since then, perhaps the most ambitious initiative in the field of human rights in the history of Ecuador. And the reasons behind the initiative, not only for Ecuador, but also for many relevant stakeholders and civil society organizations that endorsed the process, were precisely directed towards ensuring access to justice for victims like those of the Ramna Plaza building in 2013. Indeed, as Ambassador Luis Gallegos has had the opportunity to highlight in many occasions, without the support of this powerful alliance, the process would have not started as strong as it did. The first and second sessions of the working group in 2015 and 2016 were dedicated to conducting constructive deliberations on the content, scope, nature, and form of a future internationally legally binding instrument. In both sessions, the rights of the victims were clearly considered as a basis for the future elaboration of a binding instrument. During the third session in 2017, the work discussed the elements for a draft legally binding instrument prepared by the chairperson rapporteur, taking into consideration the discussions held during the first 2 sessions. This document included the objective of ensuring adequate access to justice for victims of human rights violations or abuses resulting from business activities, as well as the principle of recognition of special protection to victims, and particularly to indigenous peoples, women, girls, and children, persons with disabilities, refugees, and other groups considered vulnerable according to national, regional, or international applicable regulations. The fourth session of the working group in 2018 represented a turning point in the history of the international legal treatment of the issue of business and human rights. For the first time in history, a draft of an international treaty on this subject was formally considered within the framework of the United Nations. Under the chairmanship of Ambassador Luis Gallegos, then permanent representative of Ecuador to the United Nations in Geneva, the working group discussions focused on a zero draft legally binding instrument on business and human rights. In his opening statement, the chairman rapporteur said, "I drafted a legally binding instrument focused on guaranteeing access to justice and to an effective reparation to victims of human rights violations in the context of transnational business activities, as well as in making sure that these violations take place or repeat in the future. He also stated that as the last reports of the United Nations Human Rights High Commissioner acknowledge, despite some examples of concrete progress within certain jurisdictions, voluntary initiatives and projects still are not enough in order to protect victims of human rights and to guarantee their access to justice and effective reparation. This is why the victims of violations of human rights that keep on falling into the cracks of the shortcomings of the national and international non-binding or voluntary norms are the main purpose of this draft instrument. This even led to propose a definition of victim in the zero draft. Victims shall mean persons who individually or collectively alleged to have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment on their human rights, including environmental rights, through acts or omissions in the context of business activities of a transnational character. Where appropriate and in accordance with domestic law, the term victim also includes the immediate family or dependents of the direct victim and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization. Once again, the process of elaborating an international, legally binding instrument on business and human rights was based on the notion of access for victims of human rights abuses and violations in the framework of business activities. As a third and last point of my intervention, I will focus on the current situation of the process. Therefore, I will briefly discuss the legal configuration of access to justice for victims within the first and second revised drafts of the legally binding instrument. The second version, which was launched by the then Chairman Rapporteur, Ambassador Emilio Izquierdo, in August this year, will serve as the basis for the intergovernmental direct negotiations that will take place next week in Geneva from October 26 to 30, 2020, during the sixth session of the open-ended intergovernmental working group that elaborates the treaty. The second revised version of the draft treaty is based on the comments and observations to the first revised version presented in July 2019, and which served as a basis for the negotiations that took place in the fifth session in October 2019. That first revised version not only focused again on the victims of human rights violations by companies, but also sought to further align its provisions with existing instruments and frameworks such as the Guiding Principles on Business and Human Rights, the ILO Tripartite Declaration on Multinational Enterprises and Social Policy, and other relevant instruments such as the OECD Guidelines for Multinational Enterprises. It is important to note that the fourth and the fifth session participation of delegates from more than 90 states and approximately 400 representatives of intergovernmental organizations, civil society, unions, the private sector, experts, and academia, who provided comments and proposals to the revised version of the draft instrument. These numbers are unprecedented in the configuration of a UN working group. In the opening of the fifth session, the then United Nations Deputy High Commissioner for Human Rights, Kate Gilmore, highlighted that the future instrument will help guarantee effective prevention, protection and reparation to victims of human rights abuses in the context of business activities. Additionally, the chair rapporteur stated that the aim of the revised draft was to protect and defend victims, to prioritize the needs of human rights. Accordingly, Ecuador reiterated that the creation of this working group responded to a historic demand from the victims of human rights violations by companies. For more than 4 decades, the United Nations have tried to fill a gap in international human rights law by establishing mechanisms for access to justice and reparation. In this sense, the Ecuadorian delegation argued for the need to propose an operative definition of victims by using the Inter-American System definition laid down in Article 2 of the Rules of Procedure of the Inter-American Court of Human Rights, which defines a victim as the person whose rights have been violated according to the judgment delivered. In the course of the fifth session, the discussion on the rights of the victims revolved around the issue of access to remedy, whether there was an accurate definition of victims, as well as regarding the possible introduction of the notion of alleged victims, and in the need to reject the persons that do not have justifiable claims. In this fifth session, some states and non-governmental organizations considered Article 4 to be one of the most important articles in the instrument and critical to ensuring that those harmed had effective access to justice. Indeed, Ecuador suggested categorizing all of the provisions of the article referring to the rights of the victims under 3 headings. First, substantive rights of victims. Second, procedural rights of victims. And third, state obligations to protect the rights of victims. In accordance with the conclusions and recommendations adopted at the final meeting of the fifth session of the working group, the chairman rapporteur was asked to prepare a second revised version of the draft treaty based on the discussions held in that session. The specific proposals for amendments to the text presented at the meeting, the additional proposed amendments submitted until February 2020, and the informal intersessional consultations carried out by the chairmanship in the middle of the year. This second revised draft of the Treaty on Business and Human Rights maintains the idea of ensuring victim rights by strengthening the notion of access to justice. For example, innovations, this second version, taking into consideration the requests from various actors during the previous sessions of the working group, includes a specific reference to state-owned companies in the article of definitions, which not only guarantees equal competition, but also strengthens access to justice and reparation for victims. Moreover, with regard to victims, the new text reorganized some of the provisions according to their substantive or procedural nature and expanded the protection of victims, their representatives, families, and witnesses, including the prevention of their re-victimization. I would like to finish this presentation with the reflections. For Ecuador, the adequate conclusion of the process of elaboration of this treaty continues to be a priority of its foreign policy. Therefore, the treaty will keep on focusing on the effective guarantee of access to justice of the victims. In addition, Ecuador continues to maintain that this process and the implementation of non-binding or voluntary instruments are complementary and mutually reinforcing, and in that sense, the government of Ecuador announced on October 15, 2020, that our country will begin this year with the elaboration of a national action plan on business and human rights. Although initially some stakeholders opposed to the idea of a treaty, nowadays the number of countries and entities that are joining the process is increasing. For example, businesses that initially had some concerns on the process today clearly appreciate the importance of continuing to the elaboration of the treaty. On the other hand, since 2017, there exists legislation on due diligence of human rights in France, negotiations in Germany, the Netherlands, Switzerland, as well as a possible directive in the European Union, which points to the importance of protecting consumers and potential victims of business activities, even in developed countries. Currently, it is the very international consumer who demands compliance with human rights standards. Finally, it is likely that the future elaboration of the treaty by the working group may mean the beginning of an adoption process within the framework of the United Nations. In effect, guaranteeing access to justice for victims of serious violations is the position that could be easily assumed by a large majority of states. Furthermore, the treaty will make it possible to equalize the conditions of competition in all countries, benefiting companies and consumers by ensuring quality investments, particularly in developing countries, and thus avoiding a race to the bottom in terms of human rights standards and protection of victims. I hope this presentation may provide material for the discussion that you will have today in this topic. I thank again the organizers and Ambassador Andrés Terán for the invitation. Success in the rest of this event. Thank you for your attention.
Thank you very much, Ambassador Cabrera, for this very interesting presentation. And I think it was very clear and detailed, and it showed us the achievement of the international community with this draft of the first one of the kind of the legal binding instrument. The goal of this instrument, as you clearly mentioned it, is definitely to provide to victims of violation of human rights in business activities an effective access to justice. And this is exactly what we are going to discuss now with our two panelists, Mrs. Magdalena Neglia. She is the Director of Globalization and Human Rights at the International Federation for Human Rights. She is responsible for the implementation of the organization's strategic priority on promoting respect of human rights by economic players and coordination of the Federation activities on strengthening the international and European regulatory framework on corporate accountability and on improving access to justice for victims of corporate-related human rights abuses. She will be followed by Dr. Lucas Fogda from the University of Utrecht. He's a member of the Utrecht Center for Accountability and Liability Law. He specialized in extraterritorial jurisdiction over corporate human rights violation, and he focused his PhD thesis, on jurisdiction over foreign direct liability claims against transnational corporations in EU members, increasing access to remedy for victims of corporate human rights violations. With these two very highly qualified panelists, I'm sure we will have a very fruitful conversation this afternoon. And please, during this discussion, you will have all the opportunity later on to ask your question, but please stay on mute. Magdalena, you have the floor.
Thank you very much. I would like first to thank you very much for Republic of Ecuador, to the Kingdom of the Netherlands, and to Le Club de Droit International for this invitation, and also for organizing this important webinar that comes in a crucial time for the advancement of the negotiation of a legally binding instrument on transnational companies and other business enterprises and human rights that I had the luck to follow personally since 4 years now, and that my organization, FIDH, has supported since the beginning. So I will now share my screen so that you can all see the presentation I've prepared. So I hope it works. I would like to talk about the right of an effective remedy in the context of the legally binding instrument on transnational corporate business enterprises and human rights, because we have heard also from Ambassador Cabrera early on debate on the legally binding instrument, but more generally in the debate on business and human rights. But I would on what is the right to an effective remedy internationally. So we all know the right to an effective remedy is recognized by many instruments of international law. For example, just citing two of them, the Universal Declaration of Human Rights law that states to respect, protect, and fulfill is the access to effective mechanisms that are able to provide remedy. This is what the duty bearer, in this case the state, had to do. But also the substantive aspect is quite important, because it's fundamental that there is an effective remedy as outcome out of the process. And I want to underline these two aspects because the two of them are crucial, particularly in cases of human rights violations that are linked to business activities. That is what we are talking about today, in general, in the debate on the treaty. It is very important that the rights holder are central to the entire remedy process, what we heard before from the ambassador, but also what is form a consensus in international law. Now what I would like to do is to focus on some dimension of the right to an effective remedy and specifically illustrate those dimensions, why they are important in the context of business and human rights, and especially talking about a legally binding instrument. So first of all, it's fundamental that the diversity of any rights holders is taken into account, because any effective remedy needs to take in account that rights holders are not one, let's say, monolithic category, but there is a diversity, and it should have a specific focus on those living in vulnerable and marginalized situations. And I just wanted to make some examples taken from our experience. The first is the conception of the right to land that exists in different cultures and contexts. So, for example, in certain villages and communities that we worked with, the right to land is conceived not in a, let's say, an individualistic way as it is mainly in Western-based legal systems and cultures, but it has a profound and important collective dimension. So, for example, we had an experience with a village where there were operations from an extractive company, and the villagers had at the same time individual property, but also a very important collective property that was essential for maintaining the economic activities of the village itself. So when the company proposed a relocation plan and compensation for the land that were expropriated to construct the plant, they proposed a plan that offered to the villagers only the compensation for their individual land, while the common land, the collective land, was not taken into account in this relocation plan. So what I'm trying to say here is that, of course, in this case, we cannot say that the remedy is an effective remedy because it doesn't take in account the diversity of the rights holder, the context where this remedy is offered, and because in that case, the collective property had a very important role to play for the village and also for the economy of the village and for the livelihood of the inhabitants. Another example that I want to make is the example of women who are often differently affected by business activities, and this is not always taken into account. So, for example, women are often working at the very bottom of the chain. For example, they are the one who picks up the fruits or the vegetables in food supply chains, and the effects of pesticides or hazardous substances that are used are not measured on the health of women specifically. This is not taken into account when prevention is designed. But also, in certain cases, when women are excluded from property rights that are specifically on men, even though the women cultivates the land and they are the one who maintain the family with their work, when there is a compensation proposal from a company that comes to expropriate the land for a specific investment project, of course, women that are those who work, that are those who maintain the family, are not consulted or taken into account because the property legally pertains only to the men. This is just an example of how women could be affected differently and are affected differently by business activities, and of the importance to take this in account for designing a remedy that is truly effective. There is also, and what we see very often specifically in business and human rights cases, there is a powerful imbalance between often the company on one side and people and victims and rights holders on the other side. And this is, of course, because of the very nature of these two actors. So any remedy that is effective needs to tackle this imbalance. And for example, a very important aspect of it is the right to access to information, because one of the aspects of this imbalance is usually the fact that the information on not only on the accessibility of the remedy, but also on important aspects that are fundamental for victims and rights holders to bring their claim, such as, for example, business structures or the investment of the company, or how the company is located, where the company is located, where the headquarters is, etc. These kind of informations are not available to people, like are not transparently available. So this imbalance is also one of the aspects that usually prevent people to have access to an effective remedy. So on this aspect, just to bring it to the legally binding instrument discussion, any legally binding instrument should insist on this aspect and ensure that the diversity of the rights holders is taken duly into account, and also specifically of those that are in vulnerable and marginalized situations, and that it is reflected and put at the center of the access to remedy section. The aspect of an effective remedy is the definition of the remedy as it should be effective, accessible, affordable, adequate, prompt, and timely. These are all aspects that need to come together in order to make a remedy effective and truly complete. And for example, I want here to bring an example from our experience. We worked with a community in Brazil for a long time that lives in an area which is heavily polluted by the iron industry and steel industry. This is acknowledged by all the parties, the authorities, but also the companies. And the solution for this has been to propose a relocation to that community in a land that is not polluted. But this relocation, first of all, it took 10 years to arrive to that decision. And then last year, the relocation started. But now put it's suspended because of the difficulty to find the resources to continue the relocation. Of course, if we are talking about a relocation, in this case a remedy that comes 20 years after the beginning of the process, and of course many years after that the pollution has started, we can see that this is not an effective remedy anymore. So in this sense, any legally binding instrument should clarify that states are obliged to provide effective, accessible, affordable, adequate, prompt, and timely remedy, because all these aspects are all important in order to have a remedy that is complete. In addition, one fundamental aspect, we also, Ambassador Cabrera also talked about it, of the access to any effective remedy, is that victims and rights holders feel free from fear of victimization. What we see quite often in the business and human rights domain is, on one side, judicial harassment that is brought usually by business actors against, but also by authorities against people, human rights defenders, or individuals or communities that, or workers that speak out against violations happening in a certain company. But the form of retaliation cannot also take the form not only of judicial harassment, so cases of defamation, for example, brought against these people, but also retaliations of a different form. So, for example, we recently had an experience with some witnesses that came to speak into a judicial process against the company, and when they came back to their country, their houses were attacked. They suffered a lot of threats, and they were forced to leave the villages. This kind of episode, of course, it's unacceptable, and fear of suffer this kind of threats and retaliation is one of the aspects that prevents people to speak out, that prevents victims and rights holders to initiate a process or a claim against a business actor. So, in any legally binding instrument should prevent and properly sanction any kind of retaliation and criminalizations against individuals, communities, human rights defenders, and their representatives in business and human rights cases. And now, finally, I just want to underline that the remedies are also, we have talked about the right to an effective remedy, but the range of remedy in the legally binding instrument should be broad, so that there should be a broader definition of what is remedy, and this should include restitution, compensation, rehabilitation, satisfaction, but also guarantees of non-repetition, injunction, environmental remediation. We see how much important this is, but also ecological restoration. And an important aspect I want to underline here is the long-term monitoring that is necessary for any remedy to be defined effective and to be defined to truly respond to the needs of people. I'm coming towards the end. I just want to put all of this in the perspective of what happens during cases on business in the business and human rights domain. We have talked about the effective remedy, the two aspects, the procedural aspects on one side, the substantive aspects on the other side. But of course, we have to acknowledge that what we have in this topic usually companies that operate transnationally through very long and very complex supply chain and value chain. So we often have violations that happen in one state, but the decision makers are usually based in another state. And also the remedy, the effective remedy, can be achieved usually in a state that is different from the state where the violation occurred. This is the heart of this instrument. This is the heart of this debate. And this is one of the situations that is very challenging, as not yet be completely solved, not by the UNGPs, despite the fact that they were an important development, but we still see a lot of challenges in this. So, of course, we said at the beginning, states are obliged to provide under international law to provide an effective remedy, but this should be done also extraterritorially, so also for violations that are caused or contributed or directly linked to their companies in another state. And victims in this case needs to, and foreign victims in this case, needs to have access not only to the mechanisms we see, this is the procedural aspect, but also to the effective, this is the substantive aspect. So I will leave my colleague Professor Lucas Rorda speak about that more in the legal detail, but I just wanted to conclude saying that we, the civil society, very much hopes that the legally binding instrument that is discussed in this time in Geneva will be a milestone in this aspect, providing finally access to effective remedy and justice for victims of human rights violations linked to business abuses. Thank you very much.
Thank you very much indeed, Madalena, for giving us this point of view from your organization. It is very valuable to have you giving a concrete example of situation where truly effective remedy is definitely required to address the issue. Before you give the floor to Lucas, I would like to briefly give back the floor to the Ambassador Karen that requested it. So I will ask you the floor, Ambassador.
Thank you very much, Marine, for giving me the floor. Very briefly. Well, first of all, congratulations to Madalena. Your presentation was excellent. And I would like to thank you very much for the very important presentation made by Ambassador Arturo Cabrera, who is about to leave this webinar because he must attend several obligations at the ministry. So having said that, we say goodbye to Ambassador Cabrera, and thank you very much for this opportunity. Thank you, Ambassador.
Thank you very much, Stuart.
Thank you, Ambassador, and thank you, Ambassador Cabrera, for joining us today. That was a real honor, particularly with regard to the key role that Ecuador is playing in this discussion in Geneva. And we wish you good luck for next week's meeting at the so we will continue with our final panelist of today, from Dr. Hulda. I leave you the floor to take over our discussion.
Yes, thank you, Marine, and also thank you very much to the Embassy of Ecuador and Le Club de Droit International for inviting me on this very distinguished panel and on this very important topic. I also try to get the PowerPoint presentation ready and share it for the audience as well. I'll just highlight some of the more private international law-oriented aspects of the second draft treaty of a proposed binding instrument on business human rights. And I do realize I'll go somewhat into the technical detail, and I hope you will bear with me as I walk through some of the relevant aspects of the latest draft, and especially in the areas of jurisdiction applicable law. And even for the non-lawyers in the audience, I'll try to sort of introduce it as slowly and as comprehensively as possible, so sort of to take you along what us more technical lawyers, as ivory tower academics, discuss when it comes to instruments like these. So I first want to reiterate a point that Malena already made in her excellent presentation, and that is that from a human rights perspective, I'm sorry, I think I have a... From a human rights perspective, the obligation to provide remedies for human rights abuses is fundamentally within a state's territory and their jurisdiction. So a state only has enforceable obligations on their own territory, and generally speaking, under territory that it may not own, but that it controls, or in cases where it exercises official authority. Now, as we already heard from Madalena, one of the key issues that we face within this business human rights question is that usually when a human rights abuse occurs by a company, that abuse usually is not restricted to one territory. Either the company has roots in another state, or the damage that occurs is transnational in some way. It occurs in the supply chain. There's quite often a transnational element. So then the question becomes, do other states also have obligations or responsibilities to provide remedies? And if we look to the UN Guiding Principles, we see in Principle 25, yes, states have obligations on their own territory. And in 26, the language changes. It goes from they shall provide remedies to they should provide remedies. And it also already tells you that this is not a hard and enforceable obligation, but something that states are very much encouraged to do. Now, in order to provide access to remedy, or the recommendations that the guiding principles have are mostly framed as removing barriers. So the guiding principles recognize that, and again, as Madalena already pointed out very well, once you go transnational, you encounter a lot of obstacles that come on top of all the obstacles that a victim might have when trying to find remedy in their own state. And those obstacles can be legal. Those obstacles can be what we can call practical or procedural. And I think a lot of issues that were raised in the previous presentation, you could broadly put under the practical and procedural aspect. So what I'm going to do is talk a bit more about the legal barriers. And if we then look to the guiding principles, then in the commentary to principle 26, it talks a lot about the problems caused by the separation of corporate personality. So we might have a corporation where we have a parent company in one state and a subsidiary company or a supplier or a contract partner in another state. And while they may work together and function as one economic actor, legally speaking, they're different people, they're different entities. That's one problem. And the second problem is that victims may face is that they don't have remedial possibilities in the place where they live, in the place where the damage occurred. So they may face denial of justice, and they have to sort of navigate the maze of corporate legal persons to find another forum. And in doing so, they face a couple of legal obstacles. And for this presentation, I'm just going to focus on two. One is my first specialty, which is jurisdiction. And I'll come back to why this is a different type of jurisdiction than in the first bullet point. And the other one is, which law do you then apply to the problem? So the applicable law problem. And we're going to do this a bit from an EU perspective. I've also studied US law, I've studied the Alien Tort Statute, and if people want to raise this issue in the questions, I'd be happy to talk about it and to answer them. But my familiarity is mostly with the European Union and EU member state law. And what we see before I move on is that in absence of a enforceable obligation to provide remedies, EU states have not really addressed those barriers to remedy that they should address. Again, they're not obliged to, but they're very much encouraged to do that. And if we look at the legal reforms over the last couple of years, then judicial remedies in EU member states and those barriers for transnational cases have been mainly left intact and not really addressed that much by states. So that's sort of the perspective I'm looking at this new instrument, because the treaty may change this. It may change it from something that's encouraged to something that is obliged. And then the question becomes, what are states actually obliged to do? So again, first part is jurisdiction, and jurisdiction is a homonym. You can it can mean different things depending on the field of or the specific international law problem one is discussing. But in this presentation, I'm going to use it as the competence of a court to adjudicate a case. and that can mean whether it can say something about the substance of the case, but for this presentation, it will be whether they can adjudicate cases against particular defendants. So if you have a claim against defendants from different countries, does the court have jurisdiction over all those defendants? Now, if you look to the draft, the treaty, and you look at earlier drafts, and especially the zero draft, then that human rights meaning of jurisdiction and this private international law meaning of jurisdiction is a bit conflated. And this caused a lot of discussion after the zero draft on what is actually meant when we use the word jurisdiction. But especially in the second draft, this is much clearer. And when we then look at the specific provision, which is Article 9.1, and specifically Article 19C and Article 9.2, we see that what the treaty is trying to do is create a model that very much resembles the Brussels 1 bis regulation, which is a European instrument. It's an instrument of European law. And it basically, for Europeans, the Brussels 1 regulation for European states gives the mandatory rules for jurisdiction. And the second draft basically copies the same those same principles, at least in or at least the cornerstone principles. And what it gives jurisdiction to the courts where a particular defendant is domiciled. So a case that you have against a Dutch company should be put before Dutch courts. If you have a case before an Ecuadorian company, that should go to Ecuadorian courts, and so on and so forth. That's the cornerstone. It's very similar to the Brussels 1 regulation. And that might sound very intuitive, but I'll come back to why that is actually not necessarily a given thing in private international law. Now, what it also does is give compulsory jurisdiction. So if you have your case against your Dutch company, a Dutch court has to exercise jurisdiction. It can't just say, well, we have another doctrine, it should be somewhere else. And again, this is very, for European lawyers and for lawyers in the European continental tradition, this is very logical. This is very self-evident, but it's not necessarily for common lawyers. Now, next to this sort of cornerstone principle, you have two residual provisions. The first one is when you have two claims against two different companies, either in the supply chain or in the corporate structure, so a subsidiary and a parent. It allows courts to exercise jurisdiction over all the defendants. So you have your claim against a Dutch parent company, and you have your claim against, for instance, its Nigerian subsidiary, and you could put those claims before the same court, the Dutch court. Say, well, it's the same. It concerns the same facts, the same damage, the same victims. They're very closely combined, and if they would be adjudicated by different courts, we might get conflicting judgments, and also you would have to spend twice the amount of time and money to litigate against both defendants. So they have to be put before the same court. And if you look at most of the cases that have thus far been filed and adjudicated in European courts, this is the basic model that those cases are litigated on. So almost all civil cases against concerning human rights abuses against companies were basically on this basis. And what the treaty also does is introduce a form of necessity provision. And the form of necessity provision basically says, well, if there's no court available worldwide that can adjudicate your claim, or it's very unreasonable to require of you to go to that court. So, for instance, because you fear for your safety, because there have been natural disasters, and it's very, very doubtful that there's actually a court available. There can be a lot of different reasons, and you face denial of justice, then this case could be put before a court that accepts necessity jurisdiction. And that too is something that's common to a lot of European states. Now, not all of them, and it's also not in the Brussels regulation, but this is something that's also somewhat accepted in the European legal tradition. So all in all, if you look at the jurisdiction provisions, you'll see that the European model is basically copied and then applied specifically in this business and human rights context. Now, although I'm quite in favor of extending possibilities for bringing cases in European fora, there are two main questions that I have with the current provisions. And the first one you could say is, what problem does this actually resolve? Because if it's basically a copy of the European tradition, what sort of extra possibilities do you create, at least within the European context? And we've seen that these cases already take quite a lot of time litigating all the procedural aspects of it, because the devil is usually in the details with these cases. So adding these provisions in the Business and Human Rights Treaty for the European situation doesn't change that much, actually. It also doesn't change that much with regard to states where the damage occurred, because they usually do have jurisdiction. The problem is not that they don't have jurisdiction. The problem is that either legal systems are dysfunctional, because claimants have a problem bringing the cases locally, because even if a judgment is rendered, it may not be enforced either locally or abroad. That can be a very common problem. And this jurisdiction basis doesn't necessarily resolve that. And for the states that are in a different tradition, so for instance, the United States, this might actually be a major obstacle for actually joining the treaty, because it completely, it puts a completely different model of jurisdiction and imposes that on a state which is a common law tradition. And in the common law tradition, you don't have this compulsory jurisdiction. You have much more space for courts to weigh whether or not a case should be in this particular court, where, for instance, procedural justice and the interests of both parties are weighed against each other, rather than this very sort of black letter law, clear-cut approach from the European perspective. So this might actually be a bar for common law states such as the US, but also, for instance, the United Kingdom after Brexit, to join the treaty. So this is something I've been warning a bit about, saying, well, although it is a very interesting model to take into a common instrument like this, it does definitely come with its drawbacks. And I haven't even started discussing, for instance, Chinese law, which I don't know and personally don't know much about, but is very likely not to be exactly the same as the European system as well. So this is a private international law debate that has been going on for quite a long time. And now the instrument, it basically cuts across that debate. So that's my first sort of question. And the second one concerns applicable law. So one of, like, as I said, jurisdiction isn't necessarily the bar to cases proceeding in European courts. It is a bar, and it can take it can prolong cases quite a bit. But one of the major problems is finding some ground to litigate on, finding a reason to litigate, for instance, against the parent company. Now, what the treaty does is introduce a couple of those grounds. It gives a mandatory duty of care for parent companies, and it also introduces liability for parent companies if they violate the duty of care in Article 8, which in my view would be quite a step forward compared to the situation that we have now. Now, the problem is with that is that if you have a duty on the parent company, but you try to hold that company civilly liable, you run into applicable law rules. So if a court has to decide a case with a foreign element, they have to decide, well, but which law are we going to use? Are we going to use Dutch law? Are we going to use Nigerian law if it's a Nigerian subsidiary? Are we going to use yet another type of law? And usually in these cases, the applicable law is the law of the place where the damage occurred. So the lex loci damni. And so in business human rights cases, that might mean you have to use the law of the place where the human rights violation occurred, which can work. Yeah, I see a time reminder. I'll need, I think, about 2 minutes maximum. So you need some way to say, well, we have to go past that local law and use the forum states law, or use the mandatory due diligence laws, or the mandatory or the duty of care laws of the state where you bring the case. Otherwise, those laws become basically inapplicable in a civil context. Now, the treaty does provide some possible exceptions to that basic rule of lex loci damni, but it also creates a counter problem, that you end up with cases where you have facts occurring in one state where one of the defendants is from that state, where the victims are from that state, but you're going to use the laws of a completely foreign state that usually has not much connection to that specific to the place where that damage occurred. And when I hold these presentations, when I talk about these cases, these transnational cases, going to foreign fora, inevitably someone will bring up state sovereignty and the problem of what you get when a foreign court starts to adjudicate cases from somewhere else, especially, for instance, if it's a Western court and a non-Western state. And my argument would be that imposing Western duties of care in a foreign state would be much more invasive of that state sovereignty than using that local law and actually improving local law. Now, those are my two main points on jurisdiction applicable law. I'll leave my sort of general comments for the questions because they will inevitably turn up somehow. But I hope I sort of informed you a bit on more of the technical aspects of the treaty and some of the nitty-gritty. Thank you.
Thank you very much for your presentation, and I apologize for having to pressure you a bit to conclude. I think we would like to leave some time for the question. Maybe before to get into the question, Magdalena, if you have anything to add in 1 minute regarding the presentation of Lucas before we jump into the questions.
Thank you, Marine. Thank you very much. Just maybe very, very quickly, what I can add is that I am an academic myself. I usually, find myself into this trap of, on one side, you have the legal system, you have the legal rules, but on the other side, what we have are usually people and victims, and we have to find a solution to grant these victims the best possible remedy. And it's very difficult sometimes to explain why you cannot sue a company when you suffer the damage that it's clearly linked to that company. It's just that maybe it was done by a subsidiary that is not the same entity. So it's difficult to explain to people, okay, why I cannot say publicly that this company has damaged me, and why I cannot go there to ask a remedy, to ask compensation for what I suffered. So this, I think it's important to have this in mind when we consider those questions.
Thank you very much, Madalena, for adding this observation. Thank you again to both of you, but also to Ambassador Cabrera that had to leave us for attending other important meeting today. Thanks again to the Ambassador of Ecuador to the Netherlands for organizing this important discussion. And without any transition, I open now the discussion. If anyone has a question for our panelists or observations maybe, please do not hesitate to take the floor. You can also send your question through the chat box of our platform. Anyone? Okay, so I see, okay, here, Thomas John, and I have another one on the chat box. Thomas?
Can you hear me now?
We do.
Oh, okay. I'm terribly sorry. I tried to, it gave me, I can't unmute for some odd reason. Yes, thank you very much. My name is Thomas John. I'm from Grotius Chambers, a partner there. And I thank the organizers and the presenters very much for this very interesting topic, which is incredibly important indeed. I just have maybe two observations, and I don't purport to be completely detailed on that. It's in relation to Lucas's presentation, which I very much appreciated. Sorry, I have a bit of a private international law background, and so I very much appreciated that presentation for sure. I wanted to ask you why it is that the European model was actually chosen in the first place, given that it has actually really some considerable difficulties in terms of adopting it. You mentioned the United States. There's other common law countries that would have serious problems with this model. And why wasn't it considered to choose perhaps internationally far more accepted mechanisms, such as adopting with modifications the choice of court convention that the Hague Conference on Private International Law put out a couple of years ago, and it became effective in 2015, if I remember this correctly. The second issue that I wanted to raise was in relation to choice of law. On the one hand, I have to say I'm very happy to see that at least a level of the principle of ubiquity is creeping into this draft, even though I think it has some deficiencies still, which may in part be explainable to ensure a greater level of certainty. Here too, again, why the reversion to a more European model and not something that is globally more accepted, based on or modeled on, for example, the Hague principles on the choice of law in international commercial contracts, of course, but you know they can be modified and adopted. And one specific question that I have, which I stumbled across when I read the text again, why are the conflict rules included in the choice? Why are they not excluded? Because you're inviting yourself these terrible problems that you get from renvoi. You can debate that, of course, but where you end up either remitting back to the legal system where you started off and you didn't want to be, or you transmit into another altogether different jurisdiction again, leaving claimants as well as actually respondents in the situation where they face legal systems that they didn't consider in the first place to be. And I don't know whether you have answers to that, but there were certainly some issues that I came across that sparked my interest a little bit.
Thank you very much, Thomas. I guess if you want to maybe respond to this question, and Madalena, if you had anything to add after, please feel free. Lucas?
Yeah, sorry, I can't turn the sound on myself, so which generally is a very good thing. So to your questions, I'll try to do this shortly. The simple answer why it was chosen, I don't know. I wasn't at the negotiations, and it's quite interesting, of course, that we're taking a very European Union-based model in a negotiation where the European Union does not yet participate, to my great regret. Now, I can presume that there are of course major benefits to the European model as well, and that's mostly in the compulsory jurisdiction. And when I talk about jurisdiction, even in fora with a lot of lawyers, you see the issue of forum non-convenience pop up quite often. And of course that makes sense because the early days of business human rights litigation were mostly in first the US and then the UK, where forum non-convenience is of course a very major barrier to cases proceeding. So for the non-lawyers, it basically means a court can say, well, this case doesn't belong here, it has a better connection somewhere else, and it stays the case and removes it to a different court. And within Europe, you don't really have that forum non-convenience obstacle anymore. So my presumption would be, firstly, because well, that's not in there, and secondly, because the EU model has always been about clear, predictable rules, and in a treaty, it's going to be very difficult to take a jurisdictional model that's essentially then that's based on the presumption that courts will weigh interest later on and come up with a very good solution. You want to be clear, and you want to be predictable, and you want to be increase legal certainty both for litigants, both for claimants, for victims, and even for defendants. So although I wasn't there, I can presume that this is sort of the main reason for that.
Sorry if I just barge in right on that point.
Go ahead.
I am entirely in agreement with you. I have qualifications both in civil and common law. Of course, from a certainty point of view, leaving West tanker torpedoes and what have you not to one side, lease alibi pendants is certainly the better approach when it comes down to certainty, as opposed to the perhaps sometimes fairer approach of foreign non-convenience. There cannot be any question. But of course, what I'm driving at is the Choice of Court Convention. The Hague Conference is a global instrument that actually implements a level of certainty through a particular mechanism that actually resembles at least alibi pendants in a way by requiring a particular court to take it and all other courts to stay their proceedings, so that you don't end up in the parallel litigation world that you so appropriately described. But here we have an international global agreement with a mechanism that actually does that. Why reverting to something that actually does pose considerable problems in other jurisdictions, and in fact have been outrightly how should I say, rejected in a way. You mentioned the United States, but of course the United States has been part of the negotiations of the Choice of Court Convention. So that's where I'm sort of struggling a little bit. Why going down that path if there's a global instrument that actually is worth looking at?
Yeah, I'll try to answer this, and do this is I'll try to sort of refrain from the more technical questions you asked, but I really do invite you to just send me an email, and we really have to talk about this later. I'd be very happy to. But one thing about the Choice of Court Convention that I think is relevant for today is that the Choice of Court Convention and most, I think, of the instruments within the Hague Convention of Private International Law really presumes, you could say, sort of parity between defendants. And if there's one thing I think that Madalena emphasized very rightfully, is that in these cases, in this spectrum where we're at, there's no parity between defendants. There's no equality between victims on the one hand and the defendant corporations on the other in a lot of aspects. And there was one question I saw in the chat box that will go on that just a bit further, I think. So I'm and again, I'm leaving all the technical discussion aside just for a second, but that's, I think, one of the reasons why I wouldn't be very much in favor of taking the Hague Choice of Court model as a point of departure.
I think that can be. I think that's not 100% on point. But anyway, we do this offline in an email conversation. Or I come back to
because we still have a lot of questions in the chat box at the moment.
So sorry.
Maybe, Lucas, you were mentioning that you've seen a question where you started to respond to it. So maybe you want to follow on that specific question that you have seen on the chat box. And then we keep going with the other questions.
Yeah, so there was the question on foreign non-convenience, and I think it was Carlos's question. And that's mostly about, I sort of clicked on the word forum shopping, because when you talk about transnational cases, this will always come up. If you increase the amount of courts that people can go to, aren't they going to choose the most advantageous court for them? And my answer to that would be, yes, of course they will, but that's also what corporations do. They deliberately look for the right jurisdictions to put the right parts of their supply chain or the right parts of their corporate entity, and they, in that sense, are much more in control of where they want to be sued and where they want to have their legal battles. So if you are going to address the risk of forum shopping, I think the risk of what I would call reverse forum shopping and the large freedom that corporations have to register wherever they want. And let's be clear about this. I think the draft instrument leaves this completely intact. So the entire model, the flexible model that corporations have, and I think is at the root of some of these problems, is completely outside of the scope of the instrument. So if you are going to leave that imbalance intact and going to leave that this sort of territorial flexibility of corporations intact, I don't think the risk of forum shopping is a great counter argument to victims getting slightly more possibilities to put their cases. And even if they do, and that's the last thing I'll say, I think Madeleine already pointed out very well how these cases still pose enormous financial and organizational burdens for victims. So only like a trickle, even if you would open up literally every potential court that these cases could go to, you'll still have like a trickle of cases. It will never be like this sort of tidal wave that people presume when they start talking about forum shopping and the risk of litigation.
Thanks, Lucas. Madalena, do you maybe want to add anything about forum shopping and forum non-confidence?
Yeah, I would just add that we as civil society, we were very much, and as a FIDH, we were very much happy to see in the new draft an explicit provision to use forum non-convenience, for example. We think this is a very good step forward. And I just wanted to pick the other part of the question, or the same question about burden of proof, which I think it's one of the key, because as I said, there is this big imbalance between often victims and companies, and the shifting of the burden of proof is in this type of cases essential in order for victims to have any chance to bring the case. It can be framed, for example, as a provision that says the party that has the more, let's say, the more access to information, or has the burden of proof, for example, or has the more power in the case, as the burden of proof. Or it can also be explicitly said that the state needs to provide for a shift in the burden of proof in those type of cases. And this is because we see that it's very difficult, for example, when you have to prove that the causality link, and you also have to prove that the action of the company leads to that violation. In terms of defending victims, you don't have access to all the information you need to prove that. Specifically, internal corporate correspondence, for example, emails, information that you need and that you don't have the means to have access to. So this is a key aspect of these cases, and it's fundamental to address this balance, actually. Yeah, that's from my side.
Thank you, Madalena. We're running a bit out of time. I would like to go through all the questions that we already have in the chat box, if you don't mind. So the next question is a question from the Embassy of Mexico, and they would like to have a brief comment from you, Lucas and Madalena, about the differences / complementarity of the draft instrument and the 8 rules on business and human rights arbitration. If you have maybe a short comment, also a short observation. I still have to unmute you.
I don't know whether Lucas wants to start.
To be very honest, I'm not an expert on arbitration, so I wouldn't feel very comfortable answering this question and just going out on a limb. So I'd be happy to look into this a bit further and comment on it later. But this is really not my specialty.
Thank you.
Yeah, I also follow the same line in the sense that I don't know in detail the initiative of the 8 rules on arbitration in this case. Is what I just can say is that we see the importance of, for sure, the fundamental importance of state-led mechanisms in this aspect, because of all the problems that comes with arbitration in general, and that we could see coming for arbitration in this kind of cases, where already companies will be one of the parties, and where usually heavy economic interests are at stake. On the other side, I know a little bit the initiative. I can say about it is that I feel a bit difficult that companies will accept to sign a clause giving the arbitration to an independent organ that is chosen also by partially chosen by, for example, the victims or the representatives. So I don't know it in detail, but I feel it's for sure it cannot be the only one solution, and it might be also difficult for it to be complementary.
Thank you, Madalena. Just and this is just my personal opinion as your moderator today, but I do personally believe that they are definitely complementary, and particularly in the situation when you have states that lack of national capacity, arbitration is always a good solution. So, but we will have all the opportunity to discuss it at our next event, because we will focus on the examples on business and human rights. So you will be more welcome than to join us at this time. Our next question is coming from Kian O'Connell. So I'm reading out the question. From private international law perspective, what are some ways the draft LBI could include to ensure the extraterritorial reach of domestic private law in business and human rights cases? Any of our speakers maybe that want to respond to this question very briefly?
Maybe for the person who asked the question, could you clarify a bit what you mean? Because as far as I can see it, for instance, include obliging states to adopt, for instance, duty of care legislation is extending domestic private law to extraterritorial settings. That's how I would look at it, but I don't think that's necessarily what you mean. So could you clarify slightly what you mean with that question?
Ian O'Connell, maybe if you want to clarify this question, have unmuted me. Okay. Okay, unfortunately, we may have to proceed. Okay. So, my apologies. I think we will jump to the next question because, unfortunately, there is no reaction. So maybe we can go back and go in more detail into this question later on. But let's continue. So our next question is coming from Ines Gonçalves Pereira. I'm very sorry for my poor accent. This question is as follows. I would like to know your views on the fact that the draft legally binding instrument does not directly impose obligations on companies. Do you think that still focusing on states' obligations and not binding companies directly under international law will be an effective way of advancing the business and human rights debate? A very interesting question indeed.
I can maybe start on this.
Yes, Magdalena.
Of course, this was one of the point of the debate since the beginning. Shouldn't we impose direct obligation on companies, or should be a treaty that address mainly states? On one side, like from a legal point of view, I would say it would still be very difficult, even if it's possible in international law to impose direct obligation on companies, and this also for the question of enforcement. Who will enforce these obligations? Will it be an international court? So it's a bit difficult to separate the two questions. On the one side, the obligations without the enforcement mechanisms. On the other side, from a more, let's say, political perspective, it's also very important to stress the role of the states in regulating business, to avoid the fact that companies are already very powerful on the international scene. So providing for direct obligations is also a way to, let's say, strengthen this autonomous authority that companies have.
Thank you, Magdalena. Lucas, do you want to add anything?
Yeah, I think in general, I agree. I think the question of whether companies have direct obligations, I think the question is slightly too broad in the sense that companies already are imposed with certain duties under international law. But the problem is I think much more about, do you sort of include them as general human rights duty bearers? And I think you would sort of change the entire human rights landscape once you decide that companies do have this general duty bearer role. That doesn't mean that you shouldn't, or that you can't impose particular obligations derived from human rights law by treaty. And I think, but the draft as it is right now actually already does that in a way. It translates the human rights due diligence norm from the UN Guiding Principles into what's eventually going to be a legally binding norm. It's much more about enforcement, and like Madeleine said, it's the question is then, even if you make that into a direct duty in the treaty, it's still states who are going to have to enforce that duty. There's never going to be a general international organization that's going to enforce that duty. So it wouldn't change that much compared to the situation that we have now. And I think it's much better to focus on elaborating specifically what is meant with human rights due diligence and specific actions that company will have to take, the way and adjust their behavior, and see how that can be effectively enforced. Even through national means, then we necessarily need to sort of go back and forth on whether do they have, formally speaking, do they have duties in international law.
Thank you, Lucas. And we will take a final question because we are definitely late at the moment. So my final question for today's event is the question from Ingrid Escobar. And the question was, in your opinion, I would like to know about your opinion on the draft of the convention presented 10 years ago by the working group on the use of mercenaries as a means of violating human rights. Maybe Madeleine, Lucas, one of you would like to.
I'm sorry, but I don't know a lot about this convention, so I'm afraid I'm not able to respond to the question in a good way.
Well, I don't know much about this specific draft. I've been following the works somewhat from a distance, so I can't comment on a specific draft itself. But there's one point I'd like to make that relates to the question of mercenaries and private military and security companies, which is one of the sort of factual situations that got the whole business human rights question rolling, at least from and also for me personally, by the way. And I think one of the two main lessons from that debate is, first of all, that if you look at the 1989 convention, which was sort of the original attempt to regulate these companies, there were two main errors. The first one is that there was so much focus on the way these companies organize that it's very easy to organize in a slightly different way and fall directly outside of the regime. And that might be a lesson for this specific draft as well. Not that there are lots of reasons why they're different, but a lesson for this draft that if you start to focus on the organization and the way that companies organize themselves and not necessarily focus on the behavior or on the underlying factors, so free flow of capital, particular markets that are emerging. If you don't focus on that, then the entire regime is doomed to fail, because companies will adapt and legal persons are easy to shift, to change form, change their purpose. So that's lesson one. And the second lesson is that the original 1989 convention had a very limited number of signatories. And in that way, you could argue it functions as sort of an anti-customary law. This was the norm that states generally agree that that is not the law because they haven't signed the convention, and they weren't intending to sign the convention. And even more so, a lot of states that signed the convention then went on to use private military companies domestically. So that's also, I think, a major lesson for this convention, is that or for this draft binding instrument, it has to be strong. It has to have a wide range of states. It has to have states from very different traditions and backgrounds in order to function as a good basis for furthering the discussion, and not be a ceiling to the discussion rather than a new step, a new floor, so to speak. So in a very sort of meta sense, I say this is one. Those are a couple of lessons that we could learn from the mercenaries and PMSC discussion and the 89 treaty. But again, I don't know the recent draft, so I can't comment on that specifically.
Thank you very much, Lucas, for your answer. And I apologize if we cannot take any more questions at the moment. I think we are definitely late. So I would like, before to conclude this event, to give the floor to Ambassador Terence for some maybe conclusive remarks.
Thank you very much, Marine. I was listening very carefully on the three presentations, questions and answers, and well, I believe that this is with this debate that has been posed, for example, by Lucas, which jurisdiction, law, civil or common, and the other side of this coin, which is the victims and the access to an effective remedy. So this business and human rights and the in Geneva, chaired by the is doing tremendous work, and we must keep going. And we will have next week the sixth session, and most of the questions that has been raised here will be addressed, I'm sure, in the next round of negotiations in Geneva. To finalize my remarks, I would like to express, Marine, my appreciation for your moderation in this webinar. Also, Lester, for this opportunity to co-organize this webinar. I'm sure that we will have opportunities to do more of this events in the future on different topics. Thank you so much, and thank you to all the participants and all the persons that will attend this webinar. Thank you so much, and I give you back the floor, Marine. Thank you.
Thank you very much, Ambassador, and thanks again to you for organizing this online conference. Thank you to all the participants of today. I think that was a very fruitful discussion that we had, and I wish you all a very good day for the ones that are not in Europe, and for the others a very good evening now. Thank you, and goodbye.
Thank you. Bye.
Thank you, everyone.